That is there, Lord. That is there. After 10-15 minutes, he is saying that.
Then he can start. She's there. Ah, she's there. Okay. 16. 6%. 117. Good, very good.
The appellant's 161 was exhibited, madam. That is the primary basis, madam.
With the FIR.
Page 4 is the FIR, madam. Informant is PW1, the father of the victim, madam.
Joy Lakshmi Hanjarika. How many witnesses?
Around
Not possible to
19.
conclude.
19, madam.
19.
Yes, madam. What was the father?
Properly, should you go? What are it? How long? All testimonies are longest.
Longest Lordship.
Mr. Mahajan, possible to conclude?
Extrajudicial
Lord,
confession is
main-
corroborated with the medical witness, Lordship.
Main witnesses would be 13 and 17, madam.
No,
ex-
for the purpose of appreciation, we cannot ignore.
Then
For the
no, no.
purpose of discussion, we may ignore.
Yes, madam.
But for the purpose of understanding the case, we cannot ignore anybody.
Yes, madam.
বেশি মানে শেষ করে পারি না কালি পরহি to fix will not commit anything. We don't know about the roster. We are in darkness. That is why we are discussing. We will not commit because then after disbanding of the roster, it will not be possible to.
Yes,
We'll
madam.
just make a start. We'll not keep anything part her.
Madam.
If it goes to next week, we are there, we'll take up.
Lordship.
With that understanding, because I have already posted the last one for hearing. Thereafter, I do not know whether I will be here or my sister will be
Lordship
here.
will be here.
No, I know. I'm
No, no,
not
madam.
sure.
Yes, madam.
It is not.
Yes, madam.
I'm not sure. If I am sure, I would have said.
Yes, madam.
I'm not sure. Nobody knows, right? As on today.
Madam.
Maybe on Friday we could know.
Madam.
Okay, just we'll start. Have a start. Yes, FIR.
Page 4 is the FIR, madam. PW1 is the father of the deceased, madam. The deceased is
Informant is father of the
My
deceased.
father-in-law, madam. Madam, two accused faced trial, the accused appellant and his mother, madam. Mother was acquitted, madam.
In the trial.
In the trial, madam.
Offense?
302, madam.
Okay. Disrespect.
Sri Bijay Lakshmi, so and so, was married off to Sri Bharat Bora, alias so and so, on 2/6/10, but around 5 a.m. on 14/8/2010, as her face got half burned by the fire from gas stove, she was immediately admitted into Jorhat Medical College.
No allegation of any dowry.
No, my lord.
So it is not 304. B,
No 304, my lord.
Not true.
case of murder.
Murder, my lord.
Otherwise, 2 months,
Yes, otherwise.
unnatural,
70 days only.
demand of dowry is not there.
The amount of dowry is not there, but prior to her incident, Lordship, she rang her father one day and told that the accused kick her in
In the stomach, my lord.
the stomach.
But not demanding dowry.
No demand.
No demand was there.
My lord,
Okay.
conviction is on, my lord,
Huh?
that in the morning, the accused and the accused mother was along with the deceased, my lord.
Mhm.
And then the 161 of the accused is exhibited, my lord. That forms another basis. Then the extrajudicial confession, my lord. And then, my lord, the PM report, my lord.
13, Lordship, PW 13, 4 of this with the.
No, third ingredient is not there. Harassment. Because if it is 304, presumption would have acted against him.
On 113B, my lord. Yes, my lord.
Right. That is why.
Yes, my lord.
Okay.
That was the FIR, my lord.
Hmm.
Charge was under 302 and 34, my lord.
Her dead body is lying there. Jorhat Medical College.
My lord.
Graduated from gas stove, she was immediately admitted to Jorhat Medical College, but she breathed her last at 5:30 am. 5:30 am. When it was lodged?
On the date of occurrence, my lord.
So 5 am burn.
Around 9:15 lodge, my lord.
He died on 8:30. 8:30 AM.
FIR was lodged?
9:15, my lord.
9:15.
Yes, my lord.
9:15. Okay. Bharat Bora and Khudmai Bora. Who is Khudmai Bora?
My mother, my lord, mother-in-law of the deceased, my lord. She was acquitted, my lord.
In the FIR, it was not there.
My lord. FIR there, my lord.
Huh?
Bharat Bora and his mother to be the murderer of my daughter, my lord.
In the FIR.
Last line, my lord. I suspect my son-in-law.
Okay.
Yes, ma'am. PW1 is page 8, my lord.
You were in jail. You were in jail
I'm in jail, my lord.
since when?
Since then, date of judgment, my lord.
Date of judgment.
In between, my lord, we got that leave, my lord.
You were allowed, no. When the case was committed on 1/2/2011, you were in jail custody.
Yes, yes, ma'am.
Thereafter, you got bail
Yes, ma'am.
during the trial.
Yes, ma'am.
Yes.
Well, page 8, my lord. At present, I'm serving as a teacher in Gopal Bora LP School in Tekala Bodwa village. So and so was my daughter. We married off her to Bharat Bora as per Hindu rites and rituals on 2nd of June 2010. After her marriage, my daughter continued to do her job as a computer assistant, which she had been doing before her marriage. My daughter often used to talk to me over phone. On 9th August 2010, she told me over phone at night that her husband had kicked her that day. On 9th May. She further told me that her mother-in-law Khudmai Bora was rebuking her that night, alleging that she did not do the daily chores. My son-in-law and his mother are present in the dock today. My daughter had been doing job as computer assistant at Dergaon, Soital Mara. At 8:30 p.m. on 13 August 2010, she informed me that she got the contractual job of science teacher in Jorhat Tekela Gaon school and that she would have joined the post on 14th August.
You are residents of Golaghat.
My lord.
Golaghat or Jorhat? Jorhat.
Jorhat, my lord.
Police station?
Jorhat police station, my lord.
No. Police station case number? Jorhat.
Station case number.
Jorhat. And informant, he is from Golaghat.
Yes, my lord.
Okay. Okay.
I told her how to write the same. In the night of 13th August, I had a talk with her over mobile phone. But at 5:30 a.m. on 14th August, my son-in-law's cousin,
Hmm.
daughter of his father, elder brother, informed me that
also asked me not to write any.
my daughter had suffered burns on her face by the fire of gas stove while she was making tea.
1 minute. I will talk with her.
When I asked her as to whether my daughter had been taken to a medical hospital or not, she replied me that
I'm not following you. Just a moment.
my lord.
You start when I asked her.
When I asked her as to whether my daughter had been taken to hospital or not, she replied me that a vehicle could not be managed for that purpose. I asked her to call a 108 ambulance and take her to hospital. In the meantime, arranging a vehicle as I, accompanied by my wife, was coming to the house of my son-in-law, I got the information that my daughter had been taken to Jorhat Civil Hospital. Hence, my wife and I went to Jorhat Civil Hospital. We reached the civil hospital 7:45 a.m. and saw the dead body of my daughter there. I did not notice any specific burn on her face. I noticed a black mark.
Just a pause. Just a pause. It is civil hospital or medical college?
Jorhat Civil Hospital, they said.
In the FIR, it is medical college.
A medical college. PM report.
Huh? Here in testimony, it is civil hospital.
My lord.
In the FIR, it is Jorhat Medical College. Question is correct.
PM is also medical college. My lord.
Medical college.
Medical college.
No, civil hospital, belag.
Civil hospital.
Okay, continue. I went to Jorhat Civil Hospital. Read, hence my wife and I went to Jorhat Civil Hospital. Page
Yes,
9.
Hence, my wife and I went to Jorhat Civil Hospital. We reached the civil hospital 7:45 a.m. and saw the dead body of my daughter there. I did not notice any specific burn on her face, but I noticed a black mark measuring about 1 inch in width on her neck. I saw a little ash on her neck and nose. I noticed that a few strands of her hair above me forehead got burnt and that her tongue had protruded from mouth.
Hmm?
I saw vermilion on her forehead and her face was normal. Suspecting a foul play, I lodged an Ejahar with the PS. When I went to the hospital, my son-in-law was present there. Entering inside the campus of the hospital, I came across Robin Colita, who works in the police department. I told him that I suspected foul play in the incident. Thereafter, I went to lodge an Ejahar. On my return, I did not find my son-in-law there. Exhibit 1 is the said Ejahar. I got the Ejahar written by Kamal Chandra Gogoi. Exhibit 1 is my signature therein. One magistrate held inquest on the dead body of my daughter. Exhibit 2 is a said inquest report so and so. At that time, the investigator officer was also present there. Thereafter, the dead body was taken for post-mortem examination. Then my son-in-law was absconding. After the PM examination, the cousins of her husband took the dead body away. Niren Kakoti went to the hospital with me.
Let us see the inquest.
Page 103, man.
It is JNCH, Medical College.
Well, point number 10, man.
Stretch. Yes.
मतलब PM report is 120, 120 मतलब. Their opinion is not because of burn injury मतलब, that is because of strangulation मतलब.
Page
120 मतलब, the opinion मतलब.
120. Where is injury number 2, 3, and 4?
मतलब page 117 मतलब,
Was 17.
burn injuries मतलब.
Hmm?
2-1 superficial burn injury present.
Original objection. No, because page one, come to page 120.
Yes, there are injury number 2, 3, and 4. Yes, ma'am.
Where is the injury? 2, 3, and 4.
Not there in the,
That is why.
not there in the maluk. Yes, ma'am.
Let us see. The original one,
Yes, ma'am.
postmortem. Page 117. Huh? Owns. Pinkish in horizontal tissue. 2, 3, and 4. Wait, 2 heavy. 2, 3, 4. Wait to solve. এখানে solve. এটা solve, এটা solve. No, no. Which protruded tongue? Opposite 2, 3, 4. This is superficial, I don't know. Superficial or superficial?
It should be superficial. ma'am.
Superficial.
And then, my lord, that
Superficial. Present.
point 2, my lord, I did not, possibly internal injury, my lord.
On dissection, tissues found pinkish in color.
With a horizontal tissue
Tissues found pinkish in color. With horizontal tissue mark,
severely.
abrasion in
Ab-
upper part,
abrasion.
expanding from one side to. Let us see the original one. Something is wrong. This layman who done the inquest, he also suspected something.
My lord.
The layman like us, executive magistrate or inspector, he is suspecting something more.
Inquest is done by Dr. Lordship.
No, no, inquest, doctor.
Dr. Lordship.
Where is that? Page?
Page number.
Executive magistrate. ma'am.
Dr. PPW 16.
Oh.
Dr. Asraful.
Oh. Okay. Who has done it? Executive magistrate,
He
Dr. Asraful Alam. He's a layman like us. Inquest, not by doctor. Postmortem by doctor.
PW 16.
Come to 106. 106.
PW 16 carried out inquest as per direction of district magistrate. ma'am. PW 16 is doctor. ma'am.
PW?
16 is
16.
Dr. Asraful Amin.
Okay, doctor. But he is executive magistrate. He is PhD doctor.
That I do not know. He is doctor.
Come to 106.
Yes, ma'am.
He is an executive magistrate.
Executive magistrate.
Maybe PhD doctor or maybe MBBS doctor.
Oh.
We don't know about that.
Yes, ma'am.
But he is executive magistrate circle officer. He has suspected something. If he is executive magistrate, then it is quite adorable for him to suspect.
No,
because postmortem was subsequent to inquest.
subsequently.
As
Ah.
the Ladakh district, I was held in the
He's circle officer, otherwise. We don't know he is PhD or MBBS. We cannot say outrightly that he is PhD. It is superficial burn injury present at the front and of the neck up to the so and so, externally up to 1/3 of the so and so. On dissection tissues, what was there?
Found pinkish in color
Pinkish.
with the horizontal
Page.
117.
On dissection tissues found pinkish in color with horizontal
tissue.
Tissue mark
tissue mark.
severely. It should be abrasion man.
AB.
AB.
No, severely, that is not legible very much, but it is there clear. Abrasion in the upper part extending from one side,
other side,
Otior.
anterior.
Anterior. Otior. it is.
Yes, next one
Cantinion
also
seen in the lower part of the neck tissue on the sides.
last both
Both eyes congested and severe
here
petechial hemorrhagios.
pelachial. It should be pelachial, I think.
Hemorrhagious.
P is not there. Pelachial, perhaps. I don't know. We'll see.
Hemorrhagious.
Hemorrhages, I think. Hemorrhages.
Hemorrhage, no, it should be hemorrhage.
Hemorrhagious.
Hemorrhages. It is in the original.
Mark of
And-
ligature on the neck.
Hmm?
Fourth number point, mark of ligature,
Port
118.
118.
Eight.
4.
Not described, man.
Burn injury. Senior Medical Health Officer, Joint Director. Congested. Larynx congested. Shows pelachial hemorrhage. Petechial or petechial. Medical is pelachial or petechial. That will be clear. Interestingly, four. Mark of larynx to আছে larynx কে লিখিছে congested left lung আৰু right lung to লিখিলে shows pelachial hemorrhage to হেৰি to ক'ত গ'ল ligature no ligature cranium injury vessel larynx পাইছো right lung left lung cranium আগত এইটো cranium আগত এইটো spinal canal আমাৰ কব লিখিছে এইখিনিতে আছে গোটেইখিনি একেলগে লিখিছে এই গোটেইখিনিত এক্সটাৰ্নেল এপিয়াৰেঞ্চত এই গোটেইখিনি একেলগে লিখি দিছে বেলেগকে মানে জাগা নাই আৰু
The hyoid bone is not there.
not always necessary but quite interestingly this see page 120
Opinion.
burn injury post-mortem
In nature. Yes, ma'am.
something had happened earlier according to doctor. And it appears to be superficial,
Burn into the superficial.
Superficial.
superficial and post-mortem,
My lord.
not anti-mortem.
Right.
So basically he says, oh,
Strangulation.
mm, mm, mm. Yes.
Yes, my lord.
PW 1 cross,
Page 9, my lord.
Pelekiel. 1 minute. And OP. Pelekiel is Pelekiel hemorrhage. Skin or beneath. Pelekiel hemorrhage. Okay.
Yes, my lord. My lord, out of all the circumstances the learned trial court took for convicting the accused appellant, my lord, only two remain, my lord, as per my humble argument would be that, my lord, that they resided together that particular point of time and the post-mortem report, my lord.
Let us see that cross.
So, page 9, my lord. The marriage between my daughter and the accused solemnized with the consent of the families. The age of the mother of my son-in-law is about 65 to 70 years. I did not know if the mother-in-law of daughter suffers from any ailment. After her marriage, my daughter occasionally paid visit to my house on Saturdays. My daughter did not intimate me about any other disputes with her husband, except for the one that occurred on 9th August. I have not mentioned in the Azahar about the phone call made on 9th August. I lodged the Azahar on 14th August. Police interrogated me immediately after I lodged the Azahar. It is not a fact that on 9th August, my daughter did not phone me and informed me that her husband had kicked her and that her mother-in-law, Khudmai Bora, had rebuked her, alleging that she had not done her daily chores. It is not a fact that I did not receive any phone call on 9th August. I learned from other people that my son-in-law had taken my daughter-in-law to the hospital and I met my son-in-law in the hospital. Sometimes my son-in-law used to drop my daughter in her office by taking her there on vehicle. It is not a fact that I stated before the police that her neck had got severely burned. It is not a fact that I stated to police that I had noticed burns in the forehead, face, left hand, and on the right side below the chest of so-and-so, and that I also found her hair burned. It is not a fact that I did not state that I had noticed black mark on the neck of my daughter. I reserve, my lord. And then my son-in-law told me that he worked as a teacher in a school. Police took my statement in Jorhat Medical College outpost while my daughter was in the hospital. His 161 was recorded on, my lord, 25/8/2010, my lord. Some 4 or 5 days after that, the in charge of Rauria outpost interrogated me in Jorhat Sadar PS. It is not a fact that I had been interrogated for the first time before I lodged the Azahar. The incident took place after 70 days of marriage. My daughter visited my house several times after the marriage. After the marriage, my daughter occasionally spent nights in our house about 7 times. During that time, she did not raise any serious allegation against her husband. It is true that I did not mention in the Azahar about my daughter talking to me over phone. I did not mention in the Azahar about her mother-in-law abusing her, alleging that she had not done the daily chores. I did not mention either in the Ejahar or before the police about the phone number through which my daughter had made phone call to me on 9/8/2010. My daughter had been doing her job till 13/8/2010. On 13/8/2010, she did not raise any allegation against her husband over phone. I lodged the Ejahar against the accused person, suspecting them to have murdered my daughter. While interrogating me, the in-charge Rowdiap outpost did not ask me as to why I suspected the accused person, nor did I tell him about that. I did not say to police about my seeing of a black mark measuring about 1 inch in centimeter on the neck of my daughter when I had first seen her in the hospital, as I did not mind it then. Going to the hospital at first, I did not mind as to which parts of my daughter's body had suffered burns, but at that time of inquest, I noticed the mark in the neck and the burns on the body. It is not a fact that my suspicion is baseless. PW1, my lord. The two is the neighbor of PW1, my lord. I know Suresh Hazarika. His house is near that of mine. I knew his daughter around 5 a.m. on 14/8/2010. I was at home when Suresh Hazarika informed me that something had happened to Maina. He, along with his family members, went to inquire about the matter. Later, he called me to the medical. I reached the medical at 8 a.m. and saw the dead body of Suresh's daughter Maina in the hospital. After a short while, police arrived there and a magistrate also arrived there. When I had a look on the dead body, I noticed a black mark in the neck arising out of pressing of the neck, and that her tongue had protruded a little. I saw minor burns in her cheek and forehead. Her hair did not get burnt. I saw vermilion on her forehead. Police came there. At first, I found the accused present. Then, before arrival of the police, but later I did not find him there. Exhibit 2 is an inquest report prepared in my presence. 2-2 is my signature. Cross, my lord. It is not a fact that when police came, the accused was present there. It is not a fact that I did not state to the police that I had noticed a black mark in the neck arising out of pressing of the neck of the girl. I stated to the police that injury marks were present on the face, neck, chest, and head of Maina. It is not a fact that I have falsely stated that I noticed a black mark in the neck arising out of pressing of the neck. PW3, my lord. He is the cousin of the deceased, my lord, accused, my lord, and hostile, my lord. I know the accused person present at the dock. The accused Bharat Bora is my cousin brother, and accused Khudmai Bora is my aunt. About 1 year ago, the occurrence happened. In that incident, the wife of the accused Bharat died. My house is adjacent to the house of accused Bharat. The marriage between the deceased and the accused Bharat was solemnized 2 months prior to the death as per Hindu rites and rituals. There was no quarrel between the married couple, and there was cordial relationship between the accused and the deceased. On the date of occurrence, I was at my own house, and at that moment, at about 5:30 a.m., hearing noise from the house of the accused, I immediately rushed to the house of the accused. I noticed that accused Bharat's wife was lying in the burn condition in the kitchen, and gas stove was burning at that time. I switched off the regulator. Somebody called 108 ambulance, and the accused Bharat, along with some other persons, brought his wife to the hospital. Later on, police seized the gas stove cylinder pipe with regulator while Exhibit 3. Prosecution praised for declaring the witness as hostile allowed. Crossed by prosecution, police recorded my statement under section 161 CRPC. He has resiled from his statement under 161, my lord. It is not a fact that during 161 CRPC, I stated that since after the marriage, Bharat Bora and his mother often abused the girl. And on 14/8/2010 at about 5 a.m., I heard scream of Bharat's wife stating, "They kill me, they burn me." It is not a fact that I stated before police that this murder incident was pre-planned, and I suspected that it was done by accused Bharat and his mother, as because at the time of incident, there was only Bharat, his mother, and his wife at their house. And over and above this, I also noticed one black mark like that of strangulation by cloth in the victim's neck. Bharat's father-in-law is at Dergaon. Bharat's father-in-law's house is at Dergaon. I did not notice Bharat's father-in-law at the place of occurrence when I visited the house of Bharat. The gas stove was lying on the table and it was burning over the table. The victim was lying on the floor. The small burner of the stove was burning at that time. The victim was lying at a 5-6 feet from distance from the gas stove. There was some water lying on the floor. The water was lying prior to my arrival at the PO. I did not notice it properly on which part of the body there was burn injury of the victim. One of my uncles resides at the opposite side of the accused family, and they had no quarrel with the accused. They had visiting terms with the accused family. I heard that the deceased got a job of science teacher. I got the said news from the accused Bharat and also from some neighboring person. I did not visit the house of the accused father-in-law. I did not meet the father of the deceased after the occurrence. I heard that family of the deceased came to the place of occurrence later on. My house is at a distance of 10 meters from the house of the accused. I only noticed accused Bharat in his house while I visited his house immediately. After the occurrence and thereafter for 3-4 months, I did not meet accused Bharat. The deceased was cremated in the land of accused, but at that time of cremation, accused Bharat was not present. I met accused Bharat after his return from jail. I visited his house after their return from jail. It is not a fact that as the accused person are my close relatives, I concealed the actual fact deposed falsely. I did not collect any information how the victim died. And then again cross mirror. At the time of death, the deceased did a job and she got a new job. Accused Bharat at the time of occurrence was performing some job at school and did tuition also. At present also he works at a school. Accused had visiting terms with his father-in-law's house and family member of the house of that house used to visit the house of the accused. The deceased used to visit our house and she also visited some of the houses of the neighbor. She never gave any complaint to us against accused persons. I could know that deceased got the burn injury from the gas stove. The deceased was not in a talking condition while I visited their house and she was completely burnt at that time. I have no knowledge wherefrom police arrested accused Bharat. I could know that on the date of occurrence, accused Bharat was arrested by police. I have no knowledge whether due to his arrest, accused Bharat could not appear at the time of cremation. While I visited the house of the accused at that time, accused Bharat and his mother were crying for help from the neighbors. It is not a fact that I have deposed concealing some material facts. PW4 is again a cousin of the accused appellant, my lord. Page 17. I know the accused persons present at the dock. One of the accused is my aunt and another is a cousin brother. My house is situated at a distance of about 20-25 feet from the house of the accused. The accused performed marriage with the deceased about 2 months prior to the death. Occurrence happened in the month of July 2010. One day morning, hearing noise from the house of the accused, I came there and found that in the kitchen, the deceased was lying and my head was on the lap of my mother. My mother, his mother is PW5, my lord. My mother arrived at the place of occurrence prior to my appearance. I noticed burn injury on the head, neck, bottom of the hand of the and on the cheek of the deceased, and her wearing clothes, blouse was slightly burned and torn, and other clothes were quite okay. Some people gathered there informed me that she got burn injury from the gas stove while I visited the house of the accused. I noticed Bharat Bora busy talking with somebody over telephone. I called 108 ambulance by my phone. At that time, Bharat Bora came near to his burnt wife. When I inquired Bharat what had happened, he informed me that his wife was burnt by gas stove. I also went to the hospital and accused Bharat Bora also accompanied me to the hospital. While Bharat's wife was brought to the hospital, doctor informed that she was already expired. The doctor informed that postmortem have to be done and advised us to inform police. After our arrival, sometime later, the family member of the deceased appeared at the hospital. Police came and executive magistrate were also appeared. At that time, father-in-law of the accused Bharat Bora was present. While inquest was prepared on the dead body, we were present and I put signature. Exhibit 2 is the inquest, 2-1 is my signature. Raju Bora appeared at the place of occurrence after my arrival. Raju Bora was PW3, my lord. While I prepared at the place of occurrence, at that time, the gas stove was switched off. The deceased was lying on the floor at a distance of about 4.5 to 5 feet away from the gas stove. I do not know who switched off the gas stove prior to my arrival. Accused Bharat was not present while police and magistrate appeared at the hospital and inquest was done on the dead body. I have no knowledge where accused Bharat went at that time. I took Zimma of the dead body after postmortem. While the dead body was cremated, accused Bharat was not present at the cremation. My statement was recorded by magistrate. Exhibit 4 is a set statement. 4, 1, 2, 3 are my signature. Police also took some photograph of the dead body and place of occurrence and said photograph was seized by police where seizure list so and so, so and so. Cross. I did not hear any quarrel between the accused and the deceased. While I visited the place of occurrence, my aunt, the other accused, was lying on the bed as she was suffering from blood pressure. Accused Bharat Bora accompanied the deceased while she was brought to the hospital and he was present in the hospital till I went to the police station. He talked with doctors regarding her treatment. The deceased was not in a talking condition while she was brought to the hospital. I heard at the place of occurrence that she was burnt by fire of the gas stove. The doctor could not treat her at the hospital, and prior to providing any treatment, she expired. Probably accused Bharat informed the father-in-law about the incident. My mother came earlier to me to the place of occurrence. I have no knowledge when Raju Bora came to the place of occurrence. The deceased did not complain me or the neighbors about any ill treatment by the accused. PW5. She is the aunt of the deceased appellant, my lord, a mother of PW4, my lord. I know the accused persons present at the dock. Their names are Bharat Bora and Khudmai Bora. Bharat Bora is the son of Khudmai Bora. About 1.5 years ago, the occurrence happened. I heard noise in the house of the accused at about 5 a.m. The house of both the accused persons is situated adjacent to our house. I myself and my son Raju Bora went to the house of the accused persons. I saw the wife of accused lying in the kitchen at the house of the accused, and her clothes were burning at that time. While I went to the house of the accused persons, I met both the accused inside the house. The hairs and clothes of the wife of the accused Bharat were burning. Accused Bharat Bora was crying, holding his wife's hand. While I was present at the house of the accused persons, at that time, many other persons, including the NGO personnel, came to the place. The wife of the accused Bharat Bora was immediately brought to the hospital, and later on, I could not know that she died at the hospital. I cannot say how the fire caught on the body of the deceased. While I visited the house of the accused persons, I found that the gas stove was in burning condition. The deceased had no issues. Our house is situated at some
So
distance.
what is your explanation regarding the strangulation? It had 5 o'clock, your hostile witness, your relative, everybody said they went to your house 5:30.
My lord.
Found the disease lying in the lap of your mother or whatever, with burn injuries. Burn injury or postmortem.
Postmortem.
There are strangulation indication. So it had happened everything because thereafter public arrived. Public arrived.
My lord.
Many people, informant or whatever, his relative, your brother, your sister. But from there straight away taken to hospital.
Taken to
And you yourself have taken to hospital. So what happened prior to that? What is the explanation?
So you want to say there is no explanation. my lord.
Strangulation is clinching. Burn injury is superficial.
Yes, my lord.
Then what the law
The-
says?
on this,
Inside the house, inmates are required to explain. What explanation? Because you said, I don't know what postmortem has written, doctor has written.
yes, my lord.
Hmm? This is your explanation. See? Where is that? Question number
71, my lord.
12. I don't know what doctor had written in the postmortem. In fact, that layman also, or whatever circle officer, he said something is not correct with burn. He indicated superficial injuries.
Yes, my lord.
We have also seen photographs. Superficial. The main issue is the neck. And this pinkies, all this we have to see. Jurisprudence, medical jurisprudence. That if that is there, then you are the only inmates. Your mother got acquitted. But you owed an explanation and you owed a proper explanation.
My lord.
As clear as the sky.
Lord, in this connection, my lord,
No.
I will rely on a judgment, my lord. This is Nagendra Shah, my lord. Same as in this case, my lord. 2021 10 SEC 725.
In view of this particular post-mortem burn injury,
My lord. Same.
that lady died.
My lord.
Lady died. Then
Then burn.
sprinkling of something
Already she died.
already died. This must not be there.
There, my lord. So possibly there, my lord. Paragraph number 8, my lord. (8.1), my lord.
Hmm.
It is an admitted position of the deceased wife and the accused appellant were residing together at the time of her death, and the requisite privacy was available to the appellant to perpetrate the crime. The postmortem report and the evidence of PW9 has established that the deceased died on account of throttling of her neck. The burn injuries are undoubtedly anti-postmortem injuries. The accused tried to mislead the court by taking a false plea that the death of the deceased was due to burn injuries. The prosecution showed fairness by implicating only the appellant and not his family members.
Hmm.
The 19 minute.
1 minute. Before that. Yes. Paragraph.
19 minute. In this case, as mentioned above, neither the prosecution witnesses are deposed to the effect nor any other material has been placed on record to show that the relationship between the appellant and the deceased was strained in any manner. Moreover, the appellant was not the only person residing in the house where the incident took place, and it is brought on record that the parents of the appellant were also present on the date of the incident in the house. The fact that other members of the family of the appellant were also present shows that there could be another hypothesis which cannot be altogether excluded. Therefore, it can be said that the facts established do not rule out the existence of any other hypothesis. The facts established cannot be said to be consistent only with one hypothesis of guilt of the appellant.
But your case is not like that. There, the father-in-law was trying to extinguish the fire, and in the process, he also received burn injury.
Hello.
It is not straitjacket cut formula. There,
No, no,
the
no.
evidence is the father-in-law tried to extinguish the fire, and that has been deposed by independent witnesses.
Here, possibly.
Come to page paragraph 10.
Yes, Malak.
Third line, PW1, Sri Chandradeo Mahto stated that while the disease was boiling milk for her child, the leaves lying nearby caught fire, due to which her sari caught fire. He stated that once Sri Chandrika Prasad, the father-in-law of the deceased, attempted to put out the fire and he sustained burn injuries while doing so. In the cross-examination, he stated disease and good relation. Then, paragraph 11, he saw that all the members of the family were putting out the fire. He stated thereafter that the appellant took the disease to hospital. PW4, Prem Jadhav stated that on alarm, he also rushed to the house of the accused when he saw Chandrika Prasad, the father of the appellant, extinguishing the fire. Here, the lady lied on the lap of the mother
Lap of
with burn injury. There are witnesses who had seen it.
Malak.
Nobody had seen that lady catching fire.
Malak. But PWs came and they saw water was there, Malak.
8.1 to 8.5 matching,
Matching, Malak.
but still the case is distinguishable.
Possibly, Malak. But there was water near the deceased, Malak. And nobody came when
No, who strangulated?
here also, my lord, who strangulated, my lord. In this case, my lord, who strangulated was not
But
asserted.
here
my
the
lord.
case is different.
And there, my lord,
There are more witnesses.
yes, my lord.
Perhaps this part of testimony is ignored by the learned trial court.
Which part?
Whether this, that was paragraph 10, 11, all those are discussed. And there were many inmates.
Father-in-law, mother-in-law, and the accused appellant in the instant case.
There were many. See,
Extrajudicial confession is also made.
see
before
this
the
PW1 stated, this is what, see, PW1 stated, I guess it right, paragraph 16. PW1, third line, stated that he saw the father-in-law of the deceased extinguishing the fire. The learned trial judge has specifically discarded the testimony of PW1 to 5, right? That is what PW 4, 3, 1, they deposed regarding. Then PW 6. So at the time of the alleged incident, there were other members of the family of the accused with the accused in house.
My lord. Here also the mother was present, my lord.
Mother is acquitted does not mean that you do not owe an explanation.
My humble submission will be that to first bring 106, my lord.
106 will come definitely. Why not?
The entire chain has to be complete, my lord.
What chain is required?
There,
Nobody stayed in your house.
there is no motive. my lord.
Mother will not depose. Mother was an accused.
Mother was an accused. my lord.
Then there were no other inmates
No other
in
investment.
your house.
Yes, my lord.
At 5 o'clock,
My lord.
who will go there?
It was immediately the appellant.
Who will go? Tell me.
No,
Tell
it
me from your side.
was immediately the mother, the appellant, and
Mother was an accused.
mother was an accused, my lord.
Who will go at 5 o'clock? Morning. Who will go?
Yes, my lord. I agree.
There are only 3 inmates.
Yes, my lord. But as in the same case,
Cordial relation, okay.
cordial relationship,
But
my lord.
what about strangulation?
Look, before 106 comes in, my lord, that chain has to be proved, my lord.
Chain
That
is what
at least
is
the motive,
possible
my
to
lord.
be proved. There is another theory. What is possible to be proved, that can only be proved.
My lord,
Right?
my lord.
Prosecution cannot go inside your house at 4 o'clock and to see what was happening.
Definitely, my lord.
Yes. So 5 o'clock, something had happened. Then thereafter, hue and cry. Then people came.
And lordship will also
At
see.
least it is an admitted position that she was lying. She was not speaking. Nobody had deposed that she was speaking.
Yes, yes.
And this sprinkling might have happened. No, interestingly, no cloth was substantially burned.
Yes, my lord.
Yes.
Same in this case.
Interestingly,
Same is in this
a
case.
very limited one.
cinder mark in the neck.
And this inquest, he saw the mark.
Mark.
Then
Only 3 or 4
that
to cinder mark.
has medical evidence completely ruling out everything post-mortem. That cannot result in death. He had an idea, inquest person, but he said, I do not want to comment. But he had an idea, fair
Yes,
idea. And whatever hostile, your relative, anybody came at 5 o'clock or 5:30, nobody said that she was speaking.
No one said that, my lord.
And cloth burning, very limited. Burning, that is also limited.
The case I placed,
Sporadical.
yes, my lord. The case I placed before your lordship, my lord.
So then
There
why
also
not?
the burns were, my lord. After
Tell me
death, my
why
lord.
not the warden would shift to the accused to at least give an explanation.
I will
And
always
the
like to-
act of your absconding will
Absconding
another
is
matter.
explained.
Yes,
Absconding is explained, my lord. Yes, explain absconding, my lord.
yes, but absconding act in 2 ways,
Page
that he
68,
might be arrested.
Page 68, my lord. Yes.
He might be arrested. On that fear, he has left.
He
Is
went
it
to the
not?
hospital, my lord. Yes, my lord.
Is it not?
Page 68, he explained, my lord. PW4 has reposed truly. Page
68,
my lord.
okay. Let us see. Sixty-eight, yes.
Answer, my lord. Question number 5, my lord. Police asked me to stay away as many people tried to assault me. So I went away from the hospital and did not attend the cremation of my wife.
Okay, then when you were arrested?
I surrendered, my lord,
When?
on 26/11, my lord.
When?
26/11/2010, my lord.
26,
11,
11?
2010, my lord.
After how many days?
Around 2 months, my lord.
Hmm?
14/8,
When was the incident?
14/8/2010, my lord.
3 months.
Around 3 months.
Around 3 months. People may not wait till 3 months to assault you. Okay,
My lord.
cremation time, yes.
Yes, my lord.
But absconding also acts in 2 ways. Yes, you might have left in the fear of arrest. Or the other way is that you might be the person involved.
Yes.
Both
But I
can
have,
be presumption, inference can be drawn in 2
Yes,
ways. That you were innocent. But since you have been implicated, so avoiding arrest, you have absconded.
my lord.
This is one part. This is consistent with your innocence. Other part, that you had committed the crime, you have done, you have left it. That is not consistent with your innocence.
My lord.
Right? Both, it acts both ways.
If I had done the crime and absconded, my lord, I would not have surrendered, my lord. I surrendered before the court, my lord.
Surrender is not.
That I'm only
Surrender, okay.
I surrendered, my lord.
No,
I
what?
resisted.
How this, all those bonds were, because these are not, it appears to be manual strangulation.
In this, that Nagendra Saha, my lord, same, my lord, manual strangulation, my lord.
But there, benefit of doubt perhaps,
Benefit of doubt, my lord.
huh? There, it might be benefit of doubt,
Yes, my lord, benefit of doubt, my lord.
because there are 1 to 6, PW 1 to 6. Their evidence is that the father-in-law was trying to extinguish the fire in the process. He also received burn injuries. And there were eyewitnesses to that. But in your case, whatever your hostile witnesses were also there, who went there, hostile. I specifically telling. Nobody had said that this disease was speaking. So by that time, she was dead.
But that part is different, that no one saw me or my mother trying to save the deceased mother. Only that part is different in
No,
this.
no,
case.
not that one. This has gone to the extreme. I don't know who is the hostile or not hostile.
PW2 was 3 was hostile, my lord.
He had gone to the extent that
Page 14, my lord.
lying in burn condition in the kitchen and gas stove was burning. He switched off the regulator. So she was lying. Your wife was lying. Your wife was lying.
Which
Not
page?
in speaking condition. I think paragraph Raju Bora, PW3,
15, my lord.
page 14. Because hostile witness, entire evidence is not to be discarded.
Yes, my lord. The admissible part will come, my lord.
Then somebody said, lying in the lap of your mother.
Not my mother, my lord.
No, yes.
PW4's mother, my lord.
Huh?
PW4's mother. She is PW5, my lord.
PW?
4's mother, my lord.
Who said somewhere?
PW4 said lying in the lap of my mother, my lord. Page 17, my lord.
Hmm.
I came there and found that in the kitchen, the disease was lying and her head was on the lap of my.
Seems a Mahajan with superficial injuries, a lady could have been in a speaking condition.
Yes, my lord.
But anybody says that the lady was speaking with superficial burn injuries?
No, my lord.
No.
That is not my argument, my lord.
Yes. But things are emerging here.
Yes, my lord.
Yes, what is your argument then?
But that to bring in 106, my failure to explain would come in only when the entire chain is complete, my lord.
No, tell me, what are the circumstances required to be proved by the prosecution? Because I said
It happened inside my house, my lord.
peculiar facts and circumstances have to be taken note of.
No.
And also it is to be taken note of that prosecution is enjoined with a duty to prove the circumstances which is possible to be proved.
Yes, my lord.
Tell me now.
Well,
What are the circumstances that prosecution was required to prove? Tell me.
Well, apart from only me and my mother being in the house at the time of occurrence, the place of occurrence, my lord, 5 a.m. in the morning, only that part is proved, my lord. Other than that I had a bad relationship with my wife, or I had a motive to kill my wife because of some dowry or anything, any other thing, my lord. Nothing is there, my lord.
It is only you, yes.
And it is not that only I was there, my lord. Had only I been there along with my wife at 5 a.m. in the morning,
You are there or not?
I was there, my lord. Only me being there with my wife without there being anybody else in the house, my lord. Then yes, my lord. Only one that possibly, my lord.
Hmm.
But my mother was also there, my
No.
lord.
What are the circumstances? Please tell me. First, one by one. Let us see. Let us test your argument. What are the circumstances which prosecution did not prove? Tell me. First,
Motive, my lord.
motive. It is in your mind. Sometimes it is not possible to be proved. That is also the law.
Yes,
Second,
Second, my lord, that there is any allegation that I had previously, my lord, sought for any other mistreatment with her, my lord. That has not been conclusively proved, my lord, because even the father says that she had called me on 9th.
okay. First circumstance, motive.
Motive, my lord.
Then second circumstance, good relation.
Good relation, my lord.
It is proved. Yes. Third,
Third is that I was not alone with my wife, my lord.
you are not alone.
My mother was also there, my lord. And at that,
You were not alone.
yes, my lord. And at that point of time,
It is impossible to, since your mother was accused, it was not expected to extract any statement.
yes, my lord.
Yes, anything more?
My lord,
Your mother was there.
mother was there. Lord, now,
Okay.
who had committed, my lord? Yes, my lord. That is why I get the benefit, my lord, possibly, my lord. Because at that point of time, I will not say anything against my mother also.
Why the mother was acquitted? Let us see.
On these facts, only the mother was acquitted, my lord, saying
Let us
that
see. Let us see.
page, my lord, page 95, my lord, the circumstances, my lord.
Yes, please.
Page 95 are the circumstances relied upon by the trial court, my lord.
Let us see. Page 95.
Point number 2 is my 161 statement, my lord, that has been
One minute,
executed.
let us see all the circumstances.
Yes, my lord.
I don't know for second circumstance, I don't know.
That is 161 statement, my lord, exhibit 11, my lord.
161 statement.
Exhibited, my lord.
How? Exhibit?
Exhibit 11, my lord, that is page 124, my lord. That possibly influenced the learned court below, my lord. It is not
Through whom it was?
exhibited through the IO, possibly, my lord.
Huh?
Exhibited through the IO, possibly, my lord.
Was there any discovery?
No.
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 Yes, madam. Why this? 11? Exhibit 11?
Exhibit 11, Lordship.
Page 160?
124.
Huh?
One.
This is 161 statement.
Yes, Miss, my lord.
Why this?
Exhibited by PW,
by
PW 18, my lord.
PW 18.
3 IOs have been examined, my lord. He is one of them, my lord.
PW 18.
Page 57, my lord. Under objection.
PW 18.
Yes, sir.
PW 18.
Investigating officer.
That day I observed that if it is to be used for the purpose of section 27, only the
The 11 part.
material part is to be extracted, not the entire statement, because it Supreme Court has said, and I have also hold that it tends to influence. It has a tendency to influence. Okay, it may be excluded from consideration.
My lord. Obliged, my lord. And then the
Then let us see the next circumstance.
96, my lord. Point number 3, that would also not come into play because it was made in the presence of police officials, my lord. And this is very interesting, my lord. My 161 was recorded on, my lord.
Where is the circumstance?
Page 96, my lord. Aforesaid fact remain unshaken during evidence of PW 13 and 17. Thirteen and 17 was specifically called by the police, my lord.
Hmm?
Deal with 13 and 17, my lord.
These are 2 and 3 out.
My lord.
Say 2 and 3 out.
My lord. 4 remains, my lord. 4 is there.
4 remain.
5, I would say it has been explained in 313, my lord.
That might turn up to be false also.
My lord.
Then it goes against you.
My lord, yes, my lord.
It goes in your favor and it goes in your favor.
Both ways, my lord.
Both way.
6 has not been placed in my 313, my lord.
What?
This,
This is to presumption is to be drawn by the court. This presumption,
the circumstances which
by a process of reasoning, this is by common course of natural event, this presumption can be drawn and permissible to be drawn. This is not required. This is to be drawn. And this is permissible.
but this was never put to me in my 313, my
Not
lord,
required.
that these witness stated this
Not
and this
required.
against me, my lord.
This is a thing to be drawn by a process of reasoning with the help of 106 read with section 114.
14, my lord.
It can be, the Supreme Court has laid down in many decisions, this presumption is permissible to be drawn.
My lord. In 7, my lord, the mother is also present, my lord.
In fact, I have also drawn.
Yes, my lord. And then
This may not be that because nobody has said. So just because there was no demand of dowry, but one kick was there, except that there is nothing.
yes, my lord.
But even if we discard Roman 1, 2, and say 8,
And 7, my lord.
7, it is your submission. That is your submission. That it is cannot be drawn. And I have said that it can be possible to be drawn.
7, my lord.
Yes.
Mother incident. There is no possibility in third person committing the mother of the deceased, as only
Ah.
the accused persons were present at the time of the incident, which took place at 5 a.m. in the early
Yes.
morning.
Yes. Why not?
On this same thing, my lord, the mother has been acquitted, my lord.
Maybe for what?
At
we
what
don't
point-
know. That is also permissible. That will, what is that? Brathi.
But if the evidence can be broken so that one person can be acquitted, one person can be convicted, my lord. That
Yes, that
possibility
is also the permissible.
that is permissible, my lord.
Something has been wrongly done.
That is permissible. But if the
Something has been, suppose, whatever. Appellate court thinks that the person was acquitted. One person was acquitted by the trial court on some whatever. But still, the evidence against this person is to be individually.
evaluated, my lord. Yes, my lord. But if it cannot be broken, if the evidence cannot be broken qua each accused, my lord, then it would not be permissible, my lord.
Paragraph 31. And you have not done this, no cross-examination to this doctor. See,
Doctor, no process.
you have elicited which are adversarial to
Against-
you. See, the cross-examination you have done. Come to your
Page
page,
44.
paragraph, page. He is.
Page 45, my lord.
Mhm. See what damage you have done
Yes, my lord.
to yourself.
That is why I'm relying on Nagendra Shah, my lord. A humble submission is that in Nagendra Shah,
Mr.
strangulation.
Mahajan, we'll stop here. Possible, and we'll post it on Monday. If we continue, we'll do.
Mhm.
Right? We post it for hearing on
On
Monday.
Monday.
Just simply,
Not
without
part.
recording anything, part heard. But if we sit there, if we continue, we'll take up.
Yes, my lord.
Definitely. After normal matters, we'll take up your case. Your fees ko ache nahi kitele? Oh, Monday is what?
Monday, 9th.
Oh,
Monday is
Monday will
9th,
not be
Monday.
possible. 10th. 10th.
10th, my lord, I will not, my senior has a case outstation, my lord, I will have to assist him, my lord.
Okay, then
Any other day, my lord.
maybe 11. Because I'll be in a division bench, in a
Right.
separate division bench. And I don't know about Tuesday.
Tuesday, yes, 10 p.m.
When is it going to do?
Then
I'll list the appeal on Wednesday.
11th.
If we are there, we'll take up.
Yes, ma'am.
Huh? No, no. N. Mahajan, appellant, and A. Begum, additional public petitioner are present. Huh?
Lordship,